All right. Well, thank you all for being with us tonight. My name is Professor Jeff Gulley, and I'm joined by my colleague, Professor Tim Carlin. I'm just going to briefly just introduce myself, and then Professor Carlin will, and then he's going to get us started. We have um, a lot to talk about tonight. So, some of you I've seen in class before, some of you many times in class before, and Professor Carlin as well. But I've been teaching here almost 18 years and have been teaching at the college level for over 21 years. Been in the legal profession for more years than I care to recall now, but over 35. So, experience in employment law litigation. I was a litigator right out of law school. I had the pleasure in public service of serving as a magistrate judge and a judge for 12 years. And as I get closer to graduate to retirement someday, I don't know when that'll be. So I've been teaching now here full time uh, for Purdue Global since back in 2015. So it's our pleasure tonight to talk to you about essentials of legal research and Bluebook citation. So I'm going to mute myself and go off camera, and then Professor Garland's going to start us off. Take it
Excellent.
away.
Thank you, Professor Gulley. Yep, I know a number of you all. So hello, my name is Tim Carlin. Been teaching at Purdue Global, I think going on 15 years now. Worked in private practice, Department of Veterans Affairs, Department of Justice, smattering of different agencies, and finished up full-time, obviously now, but finished up in private practice. So I can assure you, as can Professor Gulley, what we're talking about isn't esoteric. It isn't hypothetical. This is something that you will do in your legal profession day in, day out. So let's jump right into it. So next slide, please. All right. So the first thing I want to talk about is like, well, you're the legal researcher. Like, what is our responsibility? What is it supposed to do? And this is sort of like, if we need to put it down, pencil to paper, identifying what are our roles. First is we can't do anything unless we know the facts. And then we got to identify what this legal question is. And then we move down this sort of checklist. Some of these, the time we spend on some of these checks, the marking off the to-do list can be pretty quick. Others can take a lot of time. The third one here, conducting. I'm not sure if you guys can see my cursor when I'm moving it around. Is conducting legal research can take quite a bit of time. You can, hit a home run immediately and find exactly what you're looking for, but always in the back of your mind, you're probably wondering, like, is this the case that I need? Is there something else out there? And there's some tips and tricks that you can sort of identify that you're over the bullseye. So we just see, summarizing law, drafting memos. We follow through a lot of different things within the legal field. So next slide. All right. So sort of the step process is identifying, well, who are the parties involved? Who, what, where, when, why, how. Really common in sort of writing. We sort of take that approach within the legal profession. Who are the parties involved? This can be really important understanding if we're dealing with state law, federal law. Is it a federal issue? Multiple parties. What is the issue being considered? Whenever we talk about the issue being considered, we have to think about like what is the law in question, or what is the question that the law is going to involve. Where did the activity take place? This obviously should go to questions of jurisdiction. Again, are we talking about federal? Are we talking about state? Is this, with an administrative issue? When did the activity take place? This is really important for more procedural questions about whether or not we're dealing with a statute of limitations concern. Other questions that sort of can sort of pull back and give you the 10,000-foot view is, well, why did this issue develop? Could there be concerns if it's criminal? Were there violations of procedural due process, things like that? It can sort of help add to the body of our understanding of an issue, as well as the question, how did this problem arise? Again, in the criminal aspect, a lot of people have some understanding of criminal cases, making sure that the procedural due process rights are are insured, substantive are protected. So all these questions can really go through and help you understand what you're dealing with. And I will tell you now, like, oh, should I do this every time? You should to some degree or another. Again, like I mentioned with the last slide, the more experience you have under your belt, a lot of these will just come naturally, and we can just start, rushing through these, no, not rushing, going through these quickly. Okay, next slide. All right, so if you're not familiar, the two distinctions between primary and secondary source of law. Primary source of law, it is like the law itself. This is the stuff you'll stand up in front of the judge and say, Your Honor, according to, whatever, case v. case, the court said that this is binding. And so understanding what it is that you're looking for, and you're always looking for that silver bullet, the magical case that's going to just, set your case up for victory down the path. So the first things you want to do is really start thinking about the search terms. What kind of language do you want to use? What are the key words? Is this dealing with, again, procedural due process? Well, okay, now we can start looking at Fifth Amendment. We can start adjusting the keyword searches that we want to go into. In approaching legal research, I like to sort of use the analogy of like deep sea fishing. The oceans are huge. Being able to really limit where you're searching for the cases, law, whatever it may be, that's where the restricting of your search limits will really come into play. That's like having that depth finder when you're looking for fish. Like, hey, this is the place we're looking for. I don't need to waste my time looking elsewhere for it. And that's where identifying jurisdiction, like I mentioned earlier. Chelsea, you'll become better. Well, maybe the analogy for fishermen isn't best for you, but the idea is use some of these tricks or tips to help you, and it'll go a little faster. Understanding like, hey, if I'm searching for, or if your case is federal and you're searching within state, well, that's probably not going to be what you're looking for. And again, vice versa, if it's a state issue, you live in California and there's a negligence case that's brought underneath state law, well, you can set aside federal and just focus on your California search, unless it's going to be a multiple issue. Diversity of citizenship may come into play, etc. But that's just things you need to be aware of. And again, what am I looking for? If the Constitution's on your side, you're doing really well. Like there's not a lot of stuff nothing's going to go against that. Statutes, understanding this hierarchical view of Constitution, statutes, rules, regulations, case law, again, rules, regulations, administrative law, understanding where it is you're looking for and how to approach it. Next slide. Again, we talked about primary sources of law, secondary sources of law are really, really quite helpful. Secondary sources of law will help you comprehend challenging aspects. I have one secondary source that I absolutely love. Well, ooh, I can't show it on here. Black's Law Dictionary. If there's a term that I'm unfamiliar with, break out my Black's Law Dictionary, and in plain English, it'll provide me better definition and insight into the topic. And then if I'm lucky, it'll give me also some other sources that I can use to understand the background. Encyclopedia is really broad, much like a regular encyclopedia. As you drill down into these ALRs, LR reviews, restatements, they're going to give you a lot more depth and help you find material that you're looking for. Whenever you're looking at secondary sources, you always want to make sure that the source that you have is on point, is on topic. Is there case law that's referenced repeatedly? That's one of the tips and tricks is if you keep coming back to the same case, you know that you're probably exhausting your research efforts. That you're like, hey, I found this binding case, the case that the courts look at. Black's Law Dictionary is by definition. Yeah, you'll find there'll be alternate definitions for different words, but Black's Law Dictionary, if you have a copy, you'll be doing really well. Within Westlaw, there is Black's Law Dictionary, so you don't need to buy a physical one. When I was in practice, it was just easier to just have it and just break it open because I would reference it every so often. Yep, great question. Yeah, so just be aware that if you found your source of law, again, if it's rules or regulations, fantastic. Just know that the secondary source that you're referencing, um, you the comments that you're given from the secondary source, you can't go into the court and be like, Your Honor, author Jeff Gulley said, well, he may be right, but what did Jeff cite to? That's what we want to really go to. We want to go to the primary source of law. But again, the secondary source of law really help you understand in plain English um, what the law is, what the case is, the impact, etc. And that can save you a lot of time, especially at the beginning stages of your legal research and your profession. And then again, you always want to go back and retool your search terms, making sure that the primary source of law that you're finding, either through secondary sources, is on point, and that you want to adjust it accordingly to really find what you're looking for, to fine tune it. Next slide. They can be kind of pricey. I will definitely admit that. Okay, so some further tips. Again, like bullet point one, if you start with secondary sources, be sure to get the primary sources on point. Like you do not want to go, you just don't do it. Like no one's going to do this, hopefully. You don't go into a court, don't provide a memo, don't give anything that is just citing to secondary sources. You want to get that primary source of law. Because again, if it's binding, then the court, you're making the greatest case for your client. Always read the law on point. Don't don't rely on AI to like, what does this mean? Oh, it says this. No, like there's a reason why you get paid handsomely to do your job, because you're applying the knowledge that you have to very confusing and dense material. You want to make sure that you understand the law. Don't just use someone else's interpretation, including artificial intelligence. Annotated versions are really great. Oh, I should have had one. It's like you'll have the law and then you have comments. And that's great because those comments are like, hey, that's I was kind of confused on that. And they provided some really good, insightful comments on that. And again, those comments that you see that not the law itself, secondary. Be helpful for you, but don't cite to it. You want to cite to the law itself. But again, those annotations, those comments the authors put together, really great because it can really give you some other ideas, other sources of law to look towards, both primary, secondary, but really great. Last comment, double check. We're seeing, and I'm sure if you take an LS 204, you've probably discussed ethics and legal research. If not, it hasn't come up on your degree plan yet. When you do take it, you'll become aware that as we become more digital, as we become more, entrenched within artificial intelligence, the human nature is really crucial for those validations to ensure that what you found really is the law and it means what you say it means. Next slide. All right. So the best way to get to Westlaw is to go to your course navigation, click on content, academic tools, library, and you will see once you click on the library link, midway through the page towards the bottom of the center, you'll see Westlaw Campus Research. Click on that tab, and then through the magic of the internet and everything else, Purdue will make sure you're in using your student login. You don't need a password or anything like that because you've already gone to the campus.purdue Global homepage. Next slide. And once you're there, it will bring you to this. When you see this, you're in, you're set. Okay. Yes, Brady. There have been a number of cases in which attorneys have been sanctioned for relying upon AI, and AI just creates cases that aren't really there. So we have to make sure that we assert that the case is what we say it is. Okay, I'll turn it over to Professor Gulley.
Thank you, Professor Carlin. All right. Well, now we're going to dive into the Bluebook. The Bluebook, right? Something that I have been using since all the way back into college, since I had a double major in government and paralegal studies. So I've used it for, let's say, almost 40 years now. Okay, all right. The blue book made you cry. That's not good. That's not good. It is helpful. But again, remember, it's a resource. It's a resource. Like Professor Carlin mentioned, Black's Law Dictionary. It's a, it's all about citations, but it's very important. So that's what we're going to really delve into now for the rest of our time together tonight. The 21st edition is the most current edition. I believe that was published, or I think in 2020. Not sure when there will be a new edition, but all students receive the Blue Book, your own copy, when you are enrolled in Legal Research and Writing, LS 204. You can also, and you don't need to get it. So when you take that class, Samuel, you'll get it. Then it'll be mailed to you, and you'll find if you can also go to get a subscription online. Okay. There you go. All right, everybody's sharing. So it is compiled by the editors of law reviews of the various Ivy League schools. So the purpose of citation, why in the heck do we need to cite? Well, we have to tell our audience, the reader, and if you're an attorney who's going to practice in a court of law, you want to tell the judge, right? You got to identify the document, the part of it to which you're referring, and you want them to have sufficient information to find the document or the document part, right? So a citation to a real case, not one that's, of course, hallucinated by some AI creature out there, right? Which we, Professor Carlin just mentioned, some of you have already read about it. And, it's, there was one, it happened a year or so ago. And then earlier this year, it happened again, and involved what they call themselves the largest personal injury firm in the country, Morgan & Morgan. So that's been in the news recently as well. And I'm sharing that in my legal research and writing class. But you want to make sure you allow whoever's reading your work to find the site, to find the actual source, and whether they actually want to continue to follow up. So just a citation to a case here about how judges care about citations. Yes, and this is from a judge in a case from the U.S. District Court for the Northern District of Illinois. And in part, the judge is quoted, plaintiff's complaint could have been drafted in crayon on the back of a napkin. I mean, obviously, the judge is insulting the complaint, right, in that particular case. And sometimes judges will dismiss cases. They can dismiss a complaint for failure to state an actual recognized cause of action, right, to which one is entitled relief. And sometimes defendants will allege that in their answer and motion to dismiss. Okay. So, and we'll talk more about citations. This is a citation to a case at the time that was not published. And sometimes cases do not end up meaning published in an actual reporter. We're going to talk about that as well tonight. Now, some of you, of course, have had legal research and writing, LS204. Some of you will take it in the future. So if a lot of this sounds foreign to you, tonight is just an introduction. You can go back and watch this as often as you can. And believe me, when you take LS204, your professors will go into great detail. Professor Carlin teaches it. I teach it. We have many other wonderful colleagues who teach it as well throughout the year. And but Bluebook is something that, as the slide says, that legal professionals have relied upon for many years. In fact, some jurisdictions in their court rules defer to their mode of citation. They say attorneys shall cite using Bluebook citation in all documents filed in this court. So you'll find that. Others might have court rules that might have something a bit different than the Bluebook. Obviously, if the court rules say you must cite in this manner and it's different than Bluebook, you have to cite whatever the court rules say. Yes, right. Yes, there you go, Brian. There you go. You do not need the Bluebook for LS 100, usually your first class for students, Ebony. Black's Law Dictionary. Here's an actual secondary source. Professor Carlin talked about it earlier. Here's the definition for citation. Literally, it has everything you want to know. Now, that's a picture of the 11th edition. Just last year, the 12th edition was released. So it's available for you for purchase. It's very expensive, especially if you get the hard copy. I know they even sell it in leather. Unless you really want your own copy. Plus, you can get a soft bound one. If you want to go that route, why not go that? Save some money. Or better yet, just use what's available to you for free electronically in Westlaw. Everything is there. What's available in the print volume is available to you in Westlaw. The legal sources also we're going to be drilling down on a little bit more tonight and discuss with you are first the 4 primary sources of law. Professor Carlin mentioned earlier, that's what you need to cite to in legal writing. Whether it's an internal memorandum that you're preparing as a junior associate attorney or a paralegal for your supervising attorney, or whether it's a document you're preparing for court. Primary sources of law. So you may be citing to constitutions, cases, statutes, and regulations. It could be a variety. And depending upon one's area of practice, you might be citing to more than one. You know, for example, a law firm that does a lot of administrative law will be citing to a lot of regulations and statutes, right? A lot of law firms, though, a lot of law firms will, does someone have a question? A lot of law firms will be able to, will mostly cite to primarily cases and statutes. That will be your top 2. But the 4 are the primary sources of law. That's the law itself. Westlaw has it all. Westlaw has it all for every jurisdiction, federal, every single state as well. Secondary sources we're going to talk about tonight and how to cite those. Those are helpful to our research. They can help us in our research finding the primary sources of law, helping us to understand what certain terminology means, what the court's talking about. Very, very helpful articles. Some articles you'll find just discuss a particular case. Others are a lot of law review and bar journal articles are written from an advocacy point of view. So they're advocating for a certain point of view. So they're going to contain a certain bias. So how do we cite? We begin with citing a constitution. So Bluebook Rule 11. And, you know, I don't tab mine because I have been, I've been using Bluebook so long. Sometimes I can just open to the right page, but part of it will. You don't have to memorize it. But over time, the more you use it, you will start remembering how to cite to some of the main sources, like the 4 primary sources of law, especially constitutions. You can see there, Rule 11 says you cite the state or the country. The abbreviation for constitution is always CONST period. The section or subdivision you're citing. So there's a citation to the U.S. Constitution, Article 1, Section 8, Article 1, Section 13 of the Minnesota Constitution. And Bluebook is very specific, very, very picky about spacing, punctuation, all of it, right? Also, you notice that the article number is a Roman numeral. Okay? So articles and amendments. If you were citing to Amendment 5, it would be U.S. Constitution AMEND period and the Roman numeral 5 for the 5th Amendment. Statutes. So statutes, of course, enacted by our legislative branch of government. So at the federal level, that's Congress, and at our various state legislatures as well. So we may call them codes, we may call them statutes. At the state level, that differs. That differs. They may call them rules, statutes, code books. Bluebook tells you how to cite with the correct format as well, as we'll explore. If we're talking about the federal statutes, they are compiled actually in a set of volumes called the United States Code. There's just an example of one you might find actually in a law library on a shelf. And in addition to, of course, what we have here through our library in Westlaw, you may have a community library, or some communities and cities have excellent public libraries with a great law library collection. So if you do, I would check it out sometime. Do a little exploring, take your own little field trip. So statutes, we follow Bluebook Rule 12, okay? So you're going to really learn about tonight 4 main rules, one rule for each of the primary sources of law. So Rule 11 is constitutions, Rule 12 is statutes, and then we're going to get to case law and regulations here in a moment. Oh, great, Giselle. And Oakland has one open to the public. Wonderful. Some communities do that. Others, they're closed to like members of the Bar Association. But it's wonderful when a community has something really good for the public. So federal statutes, we cite the title number, the code abbreviation, the section number of the statute. And in LS 204, we share all the shortcuts on how to do the section symbol. If you're on a Windows-based computer right now, you can type in the chat. If you've got a numeric keypad, hold down the Alt button on your keyboard, and then on your numeric keypad, enter the numbers 21, Alt 21, and you can make the section symbol. There you go, Daphne. Off the top of my head, I can't remember what it is for Mac. I think it's like Shift 6 or something. Hey, Mac's Option 6. Thank you, Catherine. Thank you. And then there's something else I have on a slide too when I teach it, LS204. I have something for Chromebook too. Someone shared with me. And the year of the spine of the volume, not the year the statute became effective. And there's a whole, if you're on an HP, it's a Windows-based computer, Devin. So yes, Alt 21, Alt 1067, but you must have a numeric keypad on your keyboard for it to work. Okay. Yeah, there's a rule on that too, Catherine, and we really discussed that a lot in LS204. Thank you all for sharing with each other the shortcut for the section symbol. So citing a federal statute, here's just an illustration. Okay. So the volume number 17, USC is the abbreviation for United States Code, the section symbol, the section number, and the year of the code. Okay, if you were looking that up in Westlaw right now, that statute, it would say that it's current through Public Law 119 dash some number, the current law passed, the most recent law passed by Congress. So you could use the year 2025 for that, because that the 119 means the 119th session of Congress that started on January 3 of this year. Judges and practitioners now delete the year of the code when you cite the United States Code. I'm still a bit of a purist. I still include the year of the code. That only started with the 21st edition of the Bluebook. In previous editions, it was required, but it's more relaxed now. However, when you cite the state statutes, you still must provide the actual year of the code. So different versions of the United States Code. Yes, there are 3 main versions. When possible, cite the official code, and the unofficial versions are from commercial publishers. And I've given you on the slide the example of how to cite to both there. Okay, if we were citing to the same statute, the official code, and then we were citing to the version we have available in West, that's what we have in Westlaw. So United States Code annotated. The competitor of West is LexisNexis, and they have their own, the United States Code Service. So you can cite to them all. They will have the same types, they'll have the same statute. If you go to the official code book, however, it will not have any annotations at the end, which are those relevant decisions, which can really help a researcher. That's why Westlaw is so excellent for legal research. Very, very helpful. And state statute. So it varies by state. In order to determine the appropriate citation format, we go to Table T1. And Table T1 in the back of the Bluebook, you can see, I'm holding it up to the camera. Hopefully you can see it. Got my virtual background, graying everything out. But you see the dark blue pages? Those are the tables in the back of the Bluebook. Very helpful. Every state's listed there. So you can go there and you can see the different citation formats for how to cite to a statute. There's 3 examples. Some states call it a code. Others call it statutes. Some have some pretty long names for it. Like Michigan is Michigan Compiled Laws Annotated. That's the West version, or just Michigan compiled laws. Again, it depends on the state. And you see the state abbreviations there. Bluebook tells us how to cite, how to abbreviate. They have their own version of the abbreviation. Minnesota is not capital M, capital N. It's M-I-N-N. Indiana is not capital I, capital N, right? Utah is not abbreviated. There are actually 6 states that are not abbreviated, according to the Bluebook, including Ohio, I mentioned. All right, so now we've talked about Rule 11. We talked Rule 12. Rule 14 applies to administrative regulations. At the federal level, they're all published in the CFR, the Code of Federal Regulations. The updates are found, more frequent updates, in the list of CFR sections affected. That's the LSA and the Federal Register. The Federal Register is also available in Westlaw. It's updated every day. The Federal Register is when the government, all government agencies at the federal level, at the end of every business day, all regulations, rules, whether it's a preliminary, a public comment rule, or final rule, all of them are compiled together in chronological order and published in the Federal Register. And West has that available as well. All of our states have similar state administrative regulations. We find out how to cite to those. Also, going to Table T1, you go to your state and you look for administrative compilation. It's actually going to be right under where you look for your state in Table T1 for statutory compilations. That gives us how to format our statutes we just looked at. And then the administrative compilation citation format is directly under that in the Bluebook. There's the example of how we cite to a federal regulation, 47 CFR, section symbol, and then the section number. The current year is used. We do not use the effective date of the regulation, the effective year, just like we do not for a statute. It can be provided in a second parenthetical, according to the Bluebook. Rule 14 also tells us what year to use in that parenthetical, just like Rule 12.3.2 tells us for the year of the code. All right, with that, I'm going to take a break, get a little hydration going, and turn it back over to my colleague, Professor Carlin.
Thank you, Professor Gulley. Okay, so we're going to sort of switch gears. We're going to look at case law. And if you're in the Bluebook, spoiler alert, Rule 10. So when we talk about case law, the word of the day is opinion. But it's not like, you know what, you can do what you want. No, like we use the word opinion when the court says, hey, this is the decision. So its decision will be known as like a case or opinion. And when we look at this, it's really good, usually written by the appellate court. And this is where our focus wants to be. We're going to put our focus because this is where we're going to find these reporters or the published decisions. And that's where we see judicial opinions are published in what are known as law reporters or just simply reporters. Next slide. All right. So a law reporter, just like the picture you can see at the bottom, is nothing more than a published volume of judicial decisions by a particular court, a group of courts. And this is what we see by these appellate courts or higher saying, hey, these are the official or published decisions. And so these reports can be what are known as official, which when they're official, it's when the government is publishing them. Unofficial is when you have private publishers, such as Westlaw and LexisNexis. So just get a good look at this. This is the Federal Reporter. You can see it says third series, and it goes in order by volume, 425, 426. So I know a lot of times we'll see oh, awesome, thank you. You'll see the numbers when you look at, and we're going to see some citations. And it's like, it's electronic. Just know that there is a physical volume that is associated with that as well. Next slide for the official reporters. All right, so this is, again, like I said, I got my handy dandy Bluebook right here. You can sort of see it. Rule 10, and you can see Brown v. Board of Education. You'll notice the abbreviations in that. Those are abbreviations. And you can see note table 6. You need to follow those abbreviations for common words. There has been a change that you can abbreviate certain words for convenience, even though the word isn't within that list. But again, you can see that the case name Brown v. Board of Education is italicized. It must be one or the other. You don't do both. You'll get some points taken off. I'm sure for Professor Gulley's class as well as mine, any other instructor. You'll notice that the comma is not underlined or italicized. We hop over to the next, the source information 347, like the previous slide. That's where if you were in a physical library, you'd find volume number 347 of the U.S. Reporter. That's the abbreviation for the official reporter. And you open up volume 347 and you go to page 483, boom. That's where the Brown v. Board of Education is going to start. And within the parenthetical, fancy way of saying the parentheses, the publication of that decision was in 1954. So again, the basics of a citation are just that. You got the case name, source information, volume, reporter, page number, and then the parenthetical with the year of the decision. And this is all at the Supreme Court level. There's some minor modifications we need to make to other cases, but we'll look at that in just a bit. Next slide, please. Oh, can you remind me why in cases like these we use the year they're issued versus the current year? Because once the court that's a great question, Chelsea. Chelsea asked the question like, well, why don't we use the current year as opposed to the year? Or why do we use the year it's published as opposed to the current year? Once that court makes its decision, there's usually no going back. That's the decision of the court. That's why it's called the court of last resort at the federal level, at the Supreme Court, because its decision is there. There are times I can send it back, but when we're looking at Brown v. Board of Education again, that's the decision, and it's not going to be updated each year. We can look back, 1954. We can still use that case today. It's still good law. Is that only for the Supreme Court? No, well, courts aren't going to revise their decisions in the future, but we could have, let's say, like appellate court makes a decision, and then the Supreme Court of the United States of America, reverses their decision 10 years later, then we would cite to the Supreme Court. We always want to cite to the highest authority possible. There are a lot of rules. I promise it gets easier. I'm sure I can come to your job and you'd be like, hey, this is what I do. And I'm like, I have no idea what I'm doing. Over time, it may get easier for me. Same thing in the law. I promise you it gets easier. Okay, so opinions Supreme Court are published in official sets called the United States Reports. This is the official reporter. We talked about Westlaw and LexisNexis. They also provide their commercial publication of these decisions. For the Thomson Reuters Westlaw, they have the Supreme Court Reporter, and you can see the abbreviation S.CT. And LexisNexis can't be outdone, so they have their own, which is known as the Lawyers Edition. So that's the L.ed. Okay, excellent. Next slide. Here's a nice little picture of the Supreme Court Reporter. Thank you very much. Awesome. Like I'd mentioned, the official U.S. Supreme Court Reporter is always published. You can see that there are times where the unofficial reporters are published as well. Here we can see the Supreme Court Reporter is published. Next slide. Samuel, so what we will do is we will upload, great question. Everyone, so Samuel says, where can we go back and rewatch this for better notes? We will share this recording onto the Legal Studies YouTube channel, probably the next day or two when we have the recording set. Oh, thanks, Saeed. All right, so here is the Lawyer's Edition. This is the LexisNexis version. And you can see annotated, just brief mention, Professor Gulley talked about it. Annotated, that's the useful comments that are secondary in nature. We don't go ahead and cite those to the court, but boy, they can really help us on our going down that rabbit hole or that deep sea fishing excursion that we're on. Annotations are fantastic. And again, we can see the volume numbers here, 18, 19, 20, 21. Those will all go into, especially if we're doing parallel citations. Next slide. Here we go. Some other good resources to see here. So please be aware that like when we have these, and I know you're probably seeing just the digital version on Westlaw, there is a physical version, especially for the Supreme Court reporters, official and unofficial, unofficial, but definitely official, that you'll be pulling off the shelf if you wanted to go the old school route. Next slide. Okay, I just mentioned parallel citation. So what does that mean? When we talk about parallel, there are certain rules that may require us to cite to publications that were made of a decision. So we have like Morgan v. United States. We can see 304, that's the volume. US, that's the official US court reporter, US Supreme Court reporter. And it's page 1. That's really easy, published in 1938. Great. So the question is, well, was Morgan v. United States published anywhere else? And if the answer is, well, yeah, it was, we may want to go ahead and cite to parallel citations. You can see here on the third bullet point, Morgan v. United States, always leading with the official US court reporter. And now we have 58 SCT. We remember what that was. That was Supreme Court reporter published by the Thompson's, Reuters, the Westlaw. Page 773, comma, we go on to LexisNexis, the lawyer's edition, 82nd volume, page 1129. This is what the parallel citation would look like. And we want to always, not want to, we always cite to the official reporter first. All right. And if you're in a Westlaw case or a Westlaw, and you're looking at a case like Morgan v. United States, you will see at the very top the three in this order that will provide you the official, US, unofficial, and parallel as well. And all that information will be ready for you. But being aware of what it is and it's available is important. Okay, next. Oh, perfect. So we already talked about the Supreme Court. Of course, Supreme Court decisions are really, well known and everyone wants to read it. What about the appellate courts? Are they there? Are they published? And the answer is absolutely. You can see the inlay here, this picture. This is the Federal Reporter third series, in volumes 37, 38, 39. And yeah, there are multiple volumes that are published. You see the Federal Reporter, and all these abbreviations are included within, there we go, within your Bluebook. F.2D, this is the second series. F.3D, boom. Since this is the textbook, you're looking at the picture, the citation would be to F.3D for Medrick v. Met Coil Systems Corporation. And so we would find volume, you can look at the citation there, volume 319, and I saw the question, could we buy these books? You could. You'd be buying a lot. I mean, you'd be buying at least 319 volumes for the Federal Reporter third series. Open up to page 910 within that 319th volume, and boom, you're there. Now, you'll notice that the parenthetical includes Seventh Circuit. And it's not just the year. For the US Supreme Court reporters, hey, we just had included the year. Why now do we include the court abbreviation? And the importance for that is, if you look at the court reporter, F.3D, the question you have to ask yourself is, do I, from the reporter, from the abbreviation of the court reporter, do I know what court is the deciding court? And if the answer is no, which if you're just looking at the F.3D, that's a really broad area that it's going to be reporting. We don't know what the court is. So that means the Bluebook says, hey, you better include the abbreviation for the court within your parenthetical previous to the year of the decision. So that's why we have Seventh Circuit, capital CIR period. All of this, Professor Gulley mentioned, very pedantic. We want to make sure every space and period is exactly where it needs to be. And that's what we need to do every time. Okay, yeah, next slide. You can see there's also supplemental reporters, and we have some good pictures here. You can see volume 878. These are case law reported select opinions from different district courts, but far and away, district court, like the trial courts, decisions usually aren't published. But if they are, select cases are published, then great, it'll be in the federal supplement. And yes, we do have abbreviations for those: FedSup, FedSup 2D, etc. You can see the citation here for Potts v. DynCorp Intern LLC. Again, it's been italicized, volume number, court reporter abbreviation, first page number. And again, within the parenthetical, since we can't look at FSUP 2D second series and know what is the court deciding that made the decision, we got to throw it in within the parenthetical. Next slide. All right. Well, again, within the Bluebook, you will find that there are regional reporters. And within the regional reporters, you just need to be aware all 50 states, as well as the District of Columbia, are divided into different regions. And this is a nice handy dandy little breakdown of all these regions. You can just look over, like I always recommend in my class, I'll do it right now, like what state do you live in? Find your reporter. And when you find your reporter, you can say, hey, that's my region. That's the reporter from my area. Mine would be the Pacific reporter, the very last one on the last bullet point. Catherine, so you're saying that case law that we would use need to have been appealed, and then yep, yes. So yes, you are, when you're going into Westlaw, you're looking for these cases that have been appealed. That's where the record really begins. That again, we talked about the supplemental. There are instances where district courts, the decisions are posted, but far and away not they're not published like they are at the appellate level. And I'm including Supreme Court in that, when I say appellate. Okay, next slide. It should be a picture of, here we go. You can see all the regional reporters. So for my visual learners out there, you can see the breakdown for the different reporters. Thank you. Awesome. Okay. Some odd boundaries, yes. All right, next slide. Okay, so we can see state cases. So we've been talking about federal. Let's look at state. Again, the same process for citations are there. Party names, italicize or underline, not both, not the comma, just the party names. Volume, you can see the reporter abbreviation, 878 first page, and you can see this is the parenthetical, Minnesota dot or min dot 1989. Again, looking at the abbreviation, we just don't know what the court is. So we have to throw the abbreviation for the court, and we can see, hey, this is the Minnesota Supreme Court. Same thing for Indiana. All of this information is included within the Bluebook for your reference, and you got to go to the states, table 1. You got to go to each state, and that's why again, I know this may be like overwhelming, getting like just a lot thrown at you. As you practice, you quickly start memorizing abbreviations, court reporters, etc. It will come. So if you're feeling like, I'm never going to do it, I assure you, you will do it. I promise you. Next slide. All right. Oh yeah, something I did not mention. Lowercase v. V dot, not uppercase V, not the VS, not capital V. Lowercase v dot is the correct when you're dividing out the parties: plaintiff, petitioner, respondent, plaintiff, defendant. The small v with a period afterwards, no space after it, is exactly what it looks like. Okay. Next slide. Hopefully everyone had a chance to look at that. All right, case names. We've talked about this already, italicized or underlined, not both. Oops, Jeff, you went back one. There we are, perfect. Do not include parties' first names. It's not John Smith v. Paul Jones. It's gonna be Smith v. Jones. If it's corporation, if it's John Smith Inc., well, okay, that's the name of the corporation, but don't include the party names, the first names within that. Next slide. All right. So year of the decision, generally only the year of the decision. If it's an unpublished, and again, you'll notice quickly within this unpublished, because it looks strange. It's like, we got the party names, great, I know that. Then we got like serial numbers, what's going on here? You got the year, and then you have the WL. So that immediately should tell you this is published within the Westlaw's unofficial version. And you can say, hey, you want to go to this page. It's the asterisk for the 4. There's a within Westlaw, you'll see it's going to be divided out asterisks. And then you, within the parenthetical, identify the court, month, day, year. Very unique. If you do need to include an unreported case, this is the process you're going to follow. And you get used to it after a while. Star paging, yes. And if you have no idea, like stars, I never noticed any stars or asterisks in there. Next time you go to a case within Westlaw, just pay attention, and you'll notice that it's a portion to the reporters that are being cited. Next slide. Big thing here. When the United States is a party to a case, you use United States, no abbreviation, no of America. It's just the United States. You can see here, United States v. Church of Scientology. This is the example. You want to follow that. That's just remember United States, nothing else, no more, no less, United States. And next slide. Okay, so within, for brevity's sake, when we have multiple citations that are going to the same source, we want to use id. That's short for idem, that means Latin for the same. And so the first time you're using the citation, you want to provide the full citation. You can see McDonald v. Eubanks, it looks good. Italicized, volume, reporter, etc. with parenthetical looks good. So the short form citation is id, assuming you're still going to page 770. If let's say that you're wanting to now cite to McDonald v. Eubanks at page 771, you put id and it's italicized dot at 771 to tell the reader, hey, same case, different page. Okay, so now I'll turn it over to Professor Gulley.
All right. Thank you, Professor Carlin. And I get to talk a little bit more about id. As Professor Carlin just said, it's more Latin for you. So you're going to learn a lot of Latin in the legal world, in the legal profession. So idem meaning the same. Bluebook Rule 4.1 tells you everything you've always wanted to know and more about id. If the same citation immediately follows the previous cite, you use id. If the same citation immediately follows the previous cite, but on a different page, you can use id at the page number. It is always italicized to reflect the Latin. It's a Latin term. Yes, and that's discussed also, Kate. When is C used? Yes, it is. It is one of the words. If you're going to see, and you may be referring the reader to a particular site in a source, and it could be used in cases. So Bluebook actually explains all of that on various types of words. For example, et sec. Okay, we didn't talk about that earlier in statutes, but Bluebook has a rule that says when you're citing multiple statutes, multiple sections, you cannot use et sec. Do not use et period, seq period. Bluebook wants you to use two section symbols, never more than two, to reflect multiple section numbers in a statutory citation. But all of this is reflected in what's great about the Bluebook too, some of you know this if you've got your Bluebook, you've had research and writing, you're taking it now. What's wonderful is the very back, the index. So the index, you can't see that on my camera, but the index actually, you can go right to it. You can just go right there and look up it. It'll take you right to the rule and page number. So it's very fast if you're not sure, okay, I know it's rule 4, but I don't know what page. Yeah, the signals, there you go. I couldn't even think of the term for a moment there, Professor Carlin. So for a non-consecutive citation, there's a way to do that as well. So you see the long citation, the first reference. So the first time you cite, literally in Bluebook in text, anytime you cite to any source in text, you must provide the full citation, even a lengthy citation to a secondary source. We're going to cover some of those. So you see there, the Fourth Amendment protects people, not places, a famous quote from Katz, full citation. And now I'm going to do a non-consecutive citation because I've talked about another source after that. And now I'm back to Katz again. So let's say I'm quoting something from Katz. You can see my quoted content, Katz, comma, 375 US at 82. So I've used a pinpoint site. I'm informing the reader to go to page 82, but you can see how it's shorter, right? I do not have to include the rest of the party name or even the year of the decision. And I jumped ahead for my pinpoint site. A pinpoint citation is also sometimes called a jump site or a pin site. People have different terminology for it. It all means the same, but you basically are telling the reader, go check this page out. Okay. And you could be, quoting, you could be paraphrasing. On the slide there, it talks about a famous case, McConnell versus the FEC. That case from 2003 is actually 300 pages. So can you imagine trying to find a quote in that case without a pinpoint site? There's actually a way to do it in Westlaw, a little that you could search for certain words and terminology pretty easily, but much better to have that pinpoint citation. The abbreviations in case names, earlier this was mentioned when Professor Carlin was going over talking about how we cite to the famous landmark case of Brown versus Board of Education. And you saw some of the words were abbreviated there. The case names, Bluebook table T6 for case names. Also, if you don't have access to it, a lot of this stuff is also available in different sites for free on the internet. The Cornell site is always great. So they have it available, the Cornell Law School, the same kinds of tables that Bluebook has in its tables as well. So you can see how committee is abbreviated, corporation, government, university. County is abbreviated in the Bluebook. City is not. Okay, city's pretty short, right? But in the Bluebook, if you go to table T6, you actually will see county is abbreviated as such. In other tables for the Bluebook, again, everything you ever want to know about abbreviating certain terms, certain words. There's court names in table T7. Like if you wanted to abbreviate the probate court, if you were citing, some states have probate courts, separate probate courts, all states do not. In some states, the civil division of a court might be a superior court, might be a circuit court, has jurisdiction over probate matters. Other states have probate courts with their own specific jurisdiction. Geographical terms, table T10. So that's where we find out how we cite to Minnesota as MINN, period. Indiana, IND, period. Table T10 also has cities and other countries around the world. And then table T13, an institutional name in a periodical like the American Bar Association. Also, and we will really go into this in depth in LS 204, we'll talk about how to cite important secondary sources. All of these sources are available to you in Westlaw. So rule 16.7.1, and there's a full citation to the Harvard Journal of Law and Technology. So the Bluebook tables tell us how to abbreviate that as well. But you can see it's the full author's name, both names, first and last, comma. Bluebook uses commas. APA format uses periods, right? It's all about the commas when you're citing various sources in the Bluebook. Other secondary sources, wonderful secondary sources in Westlaw is American Jurisprudence, AmJur, also Corpus Juris Secundum, CJS. Excellent legal encyclopedias. These are not scholarly entries, pretty easy to read. You would probably never, ever, ever cite to a legal encyclopedia in a document filed in a court of law. The judge wouldn't care for that at all. Maybe an American Law Report, an ALR annotation, that's covered by Rule 16.7.6. There you go. There's a citation to one from the ALR Fed. Some interesting articles as well. These can be a little lengthier, a little more scholarly. Again, another helpful secondary source that can help us in our legal research. Bluebook even has a rule on how to cite to the newspaper. Okay. Rule 16.6, there's an example from an article from the New York Times several years ago. There's also rules on how to cite to lots of different works like Shakespeare, the Bible, for example. There's even a Bluebook rule on how to cite to the Bluebook. All right. We only got this slide and one more. So I'm sorry, we should have finished 2 minutes ago. I apologize for that. So this is a little bit, can be a little picky, but Bluebook has a rule on how to cite to internet sources, and it really depends on what's available. Does it have a date? Does it have a current date, an amended date? So you can see I have both listed there. If it has a date listed in the source, actually, if it has a time listed in the source, like a blog post, Bluebook says you include the time right after the year. If no date listed, you see at the bottom. Okay. Excellent, Chelsea. Yes, and in LS 204, currently we cover secondary sources in Unit 5. And this is our final slide as we get close to wrapping up tonight. Just some other online sources. Earlier, some of you were asking about the official Bluebook site. You can actually don't buy the Bluebook because you're going to get it for your class, but you can actually subscribe to the online subscription there. Or when you get your Bluebook, I think they give you, I'm pretty sure you get a code in the front and they give you a 30-day free subscription to the online. So that'll be great. You can have that free. And otherwise, I think it's like $45 a year or something. And some other Cornell and Georgetown Law Library, other resources. So with that, Professor Carlin, you want to join me? Anybody have any final questions as we wrap up tonight? Feel free. Chelsea, go ahead.
Can you hear me okay?
I can hear you just fine.
Okay, perfect. Thanks. So the online sources, when you're citing that in a paper, do you include the entire URL in the in-text citation as well?
You include you include everything. So let's go back to that one. Let's say the one I have on the slide here, Emily Bazelon, in defense of new judicial activist slate. So if I was actually discussing that article by Emily Bazelon at the end of my citation, at the end of whatever I'm paraphrasing or quoting, I provide the full citation the first time. Full, everything. And I know it's lengthy, but that's the world of Bluebook. And then after that, if I refer back to it again, I would provide a short citation, like I could use it.
Okay, so so even with, I was wondering, that was my follow-up question, is if id was only for cases and statutes, or if you could also use it for
You
online
can use
sources
it.
when they're
Yes,
immediately.
definitely explore Rule 4.1 because it will tell you if you actually go to Rule 4, it will direct you to the actual rule for all of the various sources and it for primary sources, but also secondary sources as well.
Okay, that's good to know. Thank you.
Okay, absolutely, Chelsea. All right, great. Well, we're wrapping up. Thank you all for being with us tonight. We so appreciate it. I think we had at 1.50 or 51. Thank you. Thank you, John.
You all.
All right. Thanks for being here, everyone. Take care.
Have a good night, everyone. Thank you.
Happy citing.